Okay, we should be live. I'm just going to pin a comment. There we go. That will explain what we're doing. So I'm going to get straight on with it. The first bit, obviously, is a minor because we're just going to look at the docket of Mr. Hoffman, Jerry Hoffman, who was arrested at the Punta Gorda police station. I think it was police, yep, about a year ago or so. So we'll just look at the docket. A subscriber kindly sent me the original complaint, docket number 1, and they also sent me the final opinion. Just looking at the docket, I'm just going to, we had the complaint, then he filed that he was in forma pauperis, and that was granted. There you go. So he didn't have to pay to file. Obviously, probably one of Rogue Nation's men. Then he filed the amended complaint number 5 in April, and that's the one I'm going to be going through in detail together with the opinion. Let's just stricken per order second amended complaint. So he tried to file a second amended complaint, and that was stricken. Pre-trial conferences, etc. We're into June now. Endorsed order. So that is the second amended complaint being struck. So we've just got the first amended complaint. Put that back up to welcome you in so you know what we're doing. Obviously, motion to dismiss for failure to state a claim. Normal motion to dismiss, as we've seen. Hi, Alex. Hopefully I haven't caught you off guard. Right, so we've got enough, and I'm not going to go all the way down to the decision. So we'll stop at 31 there on the docket. That was just to introduce you, to give me a start to the video. Right, now on to Vegas Valley, and then we'll go back to catch you later. So Vegas Valley, this hit the docket this morning. When I looked a little earlier, it wasn't there, and now it's there. So this is the minute entry for proceedings held before Honourable Elizabeth A. Wolford. Tells us who the attorneys were. So sentencing held on 29/27/2023 for Joseph Amico. Count 1. Sentenced to 30 months in the custody of the Bureau of Prisons. Supervised release of 3 years with conditions. See judgment for standard, mandatory and special conditions of supervised release. Fines waived. $100 special assessment due immediately. And the court granted Amico's motion without objection from government for sealing of the defendant's sentencing memorandum, exhibits and supplemental affirmation. The special conditions of the supervised release weren't on the docket 5 minutes ago when I checked. So if they've hit since, I'm sorry, I'm not going to check in this live stream, but probably someone will tell me in the live chat if they come across it. So that's Vegas Valley. But let's get on to the main event, which is Catch You Later. Now, I've listed links to the videos that I did on Catch You Later on his arrest when he got thrown to the ground. This is his first complaint, which, as I say, someone sent to me, and as you can see, it's on a standard form. I'm not going to start at the top because it's got his address on it, and I'm not going to go through it because an amended complaint was filed. But just if you want to look through it, you can look through, slow it down afterwards. So this was the first complaint. So just scroll through to the bottom there. So you should be able to capture everything off that if you want to. Right. Now on to the amended complaint, the main event. So, this is Catch You Later, Jerry L. Hoffman's amended complaint and demand for jury trial against Jose Delgado and the city of Punta Gorda. One you may remember where Andrew Sheets had a case. So, it's an amended complaint and demand for jury trial. He's pro se, but he was able to file it without paying a filing fee. Introduction. This is an action for violation of plaintiff's rights under the 1st, 4th, 8th and 14th Amendments of the United States Constitution to enjoy freedom of speech, to be secure in person and possessions, to be free from cruel and unusual punishment and excessive force. Plaintiff seeks damages as well as any fees and costs associated with this action. And wait until you see how much he claims. Actually, you can probably... Let's have a few guesses in chat to see how much he actually claimed for this. 2. This action is brought by plaintiff, a citizen of the United States who was the victim of retaliatory arrest with cruel and unusual punishment, willful and purposeful unreasonable seizure his person, surely, without probable cause, justification or excuse, and interference with and denial of plaintiff's rights to free speech by denial of and interference with plaintiff's right to gather information about public officials in a form readily disseminated to others so as to promote free discussion of government affairs and which was made and done for malicious purposes only. Jurisdiction and venue. This action arises under 42 U.S.C. 1983 and 1988. Jurisdiction is founded on 28 U.S.C. 1331 and 1343. That's a 5 million from... I think that's 5 million. No, yeah. And 100 million. Right. 4. All instances material to this action occurred in Charlotte County, Florida, and defendants reside in Charlotte County. Venue is therefore proper in the Fort Myers Division of the Middle District of Florida pursuant to 28 U.S.C. 1390B and Local Rule 1.04 brackets A. Plaintiff Jerry L. Hoffman Jr. is a nonce adult... Sorry, I just added a word there. Well, I'll add it. Is a nonce adult citizen of the United States and is currently a resident of Williston, Levy County, Florida, and was a resident of Levy County, Florida during all relevant times of this action. Defendant City of Punta Gorda is an incorporated municipality of the state of Florida and at all times relevant did and still does operate the City of Punta Gorda Police Department as a department of said municipality, and said city employees all police officers who work for its City of Punta Gorda Police Department. 7. At all times relevant, defendant, the nonce, scrub that. Jose Delgado is not a nonce. I do apologise. At all times relevant, defendant Jose Delgado was employed by the City of Punta Gorda, but it does give me the opportunity to say the plaintiff is a nonce in its City of Punta Gorda Police Department as police officer, and was at all times applicable holding the rank of detective, and was at all times relevant a supervisor in the City of Punta Gorda Police Department. Factual allegations common to all counts. On 28 July 2022, at or around 2 p.m, the nonce plaintiff and 3 other photojournalists entered the City of Punta Gorda Police Department, hereinafter City Police Department, to question why no FOIA requests had been responded to and to obtain complaint forms. Nonce plaintiff planned to exercise nonce plaintiff's First Amendment right of freedom of speech in the form of audio-video recording the interaction with the City Police Department, which is a well-established form by the Supreme Court of Freedom of Speech. Nonce plaintiff was recording upon entering the public facility lobby and went to the public's window for service and requested service. Very shortly after the officer behind the window was aware Nonce plaintiff was recording, the City Police Department officer left the window without returning, denying service. 5 minutes after the denial of service, 3 officers wearing body-worn cameras and recording entered the public lobby of the City Police Department and started interacting with Nonce plaintiff and the others with Nonce plaintiff. The 3 officers were Watch Commander Jimenez, Officer Miller and Officer Berger. Watch Department Jimenez greeted the group and Nonce plaintiff requested a complaint form and was asked by Watch Commander Jimenez if Nonce plaintiff was recording, and if so, then please step outside the public lobby due to City Ordinance Chapter 15, Section 15.48, brackets D, brackets E, making it illegal to video record inside any city-controlled facility. So he's surely going to win. The Nonce is surely going to win because that's got to be an unconstitutional city ordinance, surely. 15. Plaintiff, knowing Davis v. Welcher, the assertion of federal rights when plainly unreasonably made is not to be defeated under the name of local practices, immediately informed Watch Commander Jimenez that he would be violating Nonce plaintiff's constitutional rights by enforcing the request. Watch Commander Jimenez again asked, would you please step outside due to Nonce plaintiff recording? Nonce plaintiff, knowing this to be a request, asked what would occur if the request was denied by Nonce plaintiff. Please let me know in chat if you get fed up with me saying nonce. Nonce plaintiff being threatened with trespass without due process by Watch Commander Jimenez and Nonce plaintiff having violated no laws outside or inside the public government facility, and knowing a law must be violated by plaintiff or a disturbance created by plaintiff to be trespassed from a public government facility, turned to question Officer Miller. Nonce plaintiff asked Officer Miller, if we don't comply with the request, are you going to arrest us? Officer Miller responded with, I mean you get a ticket, it's not arrestable, and further explained it would be an ordinance violation, you would be paying a fine. Nonce plaintiff's explanation to Officer Miller that Nonce plaintiff was not a threat and was willing to comply with the request because Nonce plaintiff wanted no trouble with the City Police Department was captured on several video recordings and by the lobby cameras. I'm going to drop it for now, but I may bring it in later in case we get some new viewers. Officer Miller said, your plaintiff being fined, you're being fined, sorry. Your plaintiff being fined, you're willing to step outside. Plaintiff requested to speak with the police information officer. At that moment, Detective Jose Delgado entered the public lobby and stated, have them step outside, and went directly towards plaintiff. Plaintiff, being a nonce, disabled person, and fearful due to the defendant's angry demeanour, saw the defendant was rapidly approaching and Nonce plaintiff said, please don't touch me. Yeah, I suspect he's had that said to him in other ways. Defendant immediately and unlawfully and with anger forcibly shoved plaintiff into a protruding wall corner where plaintiff fell. I imagine most of us in chat would have liked to have done that. From the floor, plaintiff exclaimed, what the hell's the matter with you? Knowing, according to common law taught, the intentional behaviour to be unlawful and plaintiff's statement obviously angering defendant Delgado. Defendant Delgado then reached down and again assaulted plaintiff a second time by grabbing plaintiff's left wrist and attempting to drag plaintiff towards the exit, causing severe pain in plaintiff's left arm and shoulder. Shame. As defendant is dragging plaintiff, making it impossible for plaintiff to regain footing, defendant forcibly says, get up. Plaintiff says, get off me, cop, and defendant ceases assaulting plaintiff by attempting to drag plaintiff and releases his hold on plaintiff's left wrist, but still standing over plaintiff, that's why I static record. Menacing Nonce plaintiff, you can read it, and allowing plaintiff to slowly and painfully regain footing while plaintiff is saying, you're a piece of shit. Why do I struggle over certain words? "You're a piece of garbage, buddy." And defendant responds with, "Then get up. Get that drama out of here. You don't tell me no," in obvious anger and on the verge of rage. At this point, plaintiff has not been informed of a citation or of a detainment or of arrest, but has been molested. He knows that word. He's a molester. Plaintiff is a molester. And battered unlawfully according to tort law by defendant Delgado due to plaintiff lawfully recording in the public lobby of the City Police Department. Immediately after plaintiff regained footing and is attempting to leave and is facing the exit and is still no threat and weaponless, defendant Delgado assaults plaintiff again for a third time with a pain compliant hold on plaintiff's left bent elbow with Hello, hello. When did the audio stop? When did the audio stop? It just seemed to have frozen. Shall I go back 34? 33? Yeah, I've got no audio. I don't know when it stopped. Yeah, I've got no audio. I don't know when it stopped. Okay, let's go to 34. Okay. Plaintiff, while saying, "Get off me, man," and still not detained or arrested, quickly moves plaintiff's own left elbow, with left hand still holding the camera phone, straight down and away from defendant Delgado towards plaintiff, breaking the pain-compliant hold defendant Delgado has on plaintiff's person and enraging defendant Delgado even more. A full second goes by, and defendant Delgado retaliates by striking plaintiff so hard the blow immediately shuts off plaintiff's recording camera phone, and the damaged camera phone goes flying into the wall as defendant Delgado, now in a rage, falsely accuses plaintiff by saying, "You can't strike me," loudly for the other officers in the room to hear, and grabs plaintiff's left arm, again swinging plaintiff around and into a closed door and onto the floor while saying, "You're under arrest." Plaintiff, hearing defendant Delgado say the words, "You're under arrest," lays unmoving, unresisting, and in painful shock on the floor where thrown by defendant. As defendant Delgado cruelly and unnecessarily lands on plaintiff's back with a knee strike causing plaintiff considerable agony and bodily damage to that area. Personally, I would have liked to have kicked him in the balls because the plaintiff is a nonce. And grabbing and twisting plaintiff's left wrist in a pain compliant hold. Defendant orders plaintiff to put your hands behind your back, and switching knees and twisting plaintiff's left wrist viciously and unnecessarily, deliberately lands a second knee strike, this time to the back of plaintiff's exposed neck, causing more bodily damage and severe pain, all while plaintiff remains prone and unresisting on the floor in a state of shock and complying with and answering Defendant Delgado's order with "Yes, sir." After the retaliatory arrest, wrist twisting, and 2 unnecessary and damaging knee strikes against plaintiff, Defendant Delgado handcuffs the still unresisting plaintiff while Watch Commander Jimenez, with body-worn camera recording, is kneeling on the floor close beside plaintiff's head to assist defendant. Immediately after plaintiff is retaliatory arrested and handcuffed, defendant stands up and, using more excessive force, pulls viciously and forcefully on the handcuffs straight upwards and towards plaintiff's face-down head in order to inflict more abuse and pain, very nearly separating separate. I can just imagine this. It's like pulling a chicken carcass apart. Very nearly separating plaintiff's shoulders out of the shoulder sockets and demanding impossibly for plaintiff to get up. Plaintiff screams in pain, attempting to inform Defendant Delgado of plaintiff's disabilities, to no avail due to Defendant Delgado's rage. Defendant finally allowed plaintiff to stand as ordered, but plaintiff required assistance from Watch Commander and defendant to stand. Plaintiff was moved to a back room of the City Police Department and questioned by still angry defendant without Miranda warning. Interesting. Plaintiff was never searched in any way and was retaliatory arrested and falsely charged with assaulting an officer EMT, resisting arrest with violence, and trespass after warning on Defendant Delgado's perjured arrest report, and plaintiff's body-worn camera was stolen by the police for exercising plaintiff's First Amendment right to video record in public. After the excessive force retaliate... What's happened here? My browser has just frozen. I may have to restart this because the browser has... I've got a relatively decent PC and the audio has crapped out on me, and now my mouse is working, as you can see, but I just can't move the browser. I can't switch screens. Wonder if I open a new window whether that will change it for me. Looks like Google Chrome has crashed, which is a real pain. We got to 44, 45. I think what I'm going to have to do is close this one down, shut the computer down, because I can't release... Hang on, let me try one thing. I'm just going to go and do a Alt-Control-Delete, bring up my task manager, delete, stop all Google Chrome. Where are you? There you are. So the screen will probably go blank for a second. There, the screen has gone blank. Let's start Google Chrome again. And let's restore pages. Right. I could let's do this. No, I won't do that. Let's capture that window again. I apologize for the interruption. We might have to capture a new window. Let's add a new source. Window capture, add source. Add source. This is very weird. Why would Google Chrome hang up like that? I can't find the window. Okay. I don't know what I'm showing on screen at the moment. I'm probably showing a lot of rubbish. Talk amongst yourselves. I'm obviously going to have to take this out when I add new source, add source. Where is it? Which source is that bringing up for me? That's that one. Let's shut that one down. Sorry, I have got the source, the PDFs up. That's just not picking it up for me. This is, I suppose, one of the... There we go. Right. So we're back on 5. I think we got to about 44. Let me expand up. Minus down. Right, how's that? That looks all right to me. We'll just get these windows in the right order now. Delete that one. Right. I'm almost back on, don't like the size of that window. Just bear with me while I get this in a decent spot. Yeah, say 45 I'm seeing in chat. Right. We're there. 45. After the excessive... Yeah, thank you. After the excessive forced retaliatory arrest, plaintiff went to the hospital for scans to determine any bones broken, but no broken bones were found, and plaintiff was then kidnapped for 65 hours. Had defendant Delgado been using a body-worn camera, as required of him by the City Police Department's policy, such video and audio would have confirmed that all the events set forth by plaintiff are true and correct. Plaintiff's own video, officer body-worn cameras videos, the City Police Department's public lobby cameras videos, and audio confirms that all the events set forth by plaintiff are true and correct. Prior to the events with plaintiff on 28 July 2022, defendant has been shown on independent news videos to deliberately violate citizens' civil rights with violence and without regard for consequences. Defendant Delgado committed perjury in his official arrest report. Prior to the events on 28 July 2022, defendant Delgado had received no de-escalation training. Count 1, 42 U.S.C. 1983 claim against defendant Delgado. Plaintiff realleges paragraphs 1 through 48. Defendant Delgado, by his actions alleged above in confiscating plaintiff's body-worn camera without a warrant and in battering, detaining and arresting plaintiff, knowing without justification and probable cause and based upon false and fabricated justifications on his official arrest report, effective an unreasonable seizure and arrest of plaintiff and used excessive force doing same that caused plaintiff permanent personal injury, emotional suffering and other manner of damages. Other manner of damages? What are they? In violation of the 4th and 14th Amendments to the United States Constitution, and same is actionable under 42 U.S.C. 1983. Defendant Delgado, acting under colour of law, citation, and by his actions alleged above, in battering, dragging, knee-kicking, unresisting plaintiff, wrist-twisting, and violently pulling arms upwards towards the head on face-down handcuffed plaintiff, in order to punish without adjudication and cause undue pain, as in Roshin, this behaviour shocks the conscience and violating Section 20, another citation, and the due process of plaintiff's 8th and 14th Amendment, and cause plaintiff permanent personal injury, emotional suffering, and other manner of damages in violation of the 8th and 14th Amendments to the United States Constitution, and same is actionable under 42 U.S.C. 1983. Defendant Delgado, by his actions alleged above in arresting, detaining, citation the mere grasping, cruelly punishing, battering, because plaintiff was video recording police in public, a recognised and protected form of freedom of speech under the First Amendment. Because plaintiff was video recording police in public, he was actually in a police lobby, if you remember. Freedom of speech under the First Amendment. Well-known one there. There's a citation, Smith v. Cumming. And in instigating his detention, punishment and battery of plaintiff de facto in punishment for plaintiff video recording in the City Police Department's public lobby, and to dissuade and discourage plaintiff from making video recordings of defendant or other police officers in the future, knowingly without justification or probable cause, and based upon false fabricated justifications, invalid under the law, effected an unreasonable seizure and arrest of plaintiff, and used excessive force, doing the same that caused plaintiff permanent personal injury as well as mental pain and suffering in violation of the First Amendment and 14th Amendments to the United States Constitution, and same is actionable under 42 U.S.C. 1983. As a result of defendant Delgado's intentionally perjuring his sworn affidavit, citation, on 28 July 2023 at 17:59:59 hours, I wonder if that was checked against Google clocks. No sound? My microphone is moving on the screen. Maggie, maybe you're in a bit earlier when I lost sound. '53. As a result of defendant Delgado's intentionally perjuring his sworn affidavit, citation on 28 July 2023 at 17:59:59 hours, sworn to by means of physical presence before notary public Fernando Berger, who signed same at 28 July 2023 at 18:00:44 hours, the affidavit is vastly incongruent with police body-worn camera videos and defendant Delgado's malicious conduct respecting plaintiff was kidnapped for 65 hours and is falsely charged with felonies and is defending same in court. Plaintiff has suffered and continues to suffer a complete lack of interest in photojournalism. That's maybe because he was called out as a nonce. Lack of interest in friends and family. Well, that's probably good for the friends and family, specifically those that are younger. Has suffered and continues to suffer serious physical injuries consisting of soft tissue damage to neck and lower back, confining plaintiff mostly to bed. Plaintiff has suffered and continues to suffer psychological injuries consisting of mental pain, anguish, humiliation, shame, and public ridicule. Yes, you're a nonce, and you deserve public ridicule, as well as suffered inconvenience, discomfort, and financial expense. Wherefore, plaintiff demands judgment against defendant Delgado for compensatory property damages in the amount of $840, punitive damages in the amount of $5 million. Someone did say $5 million very early on. Court costs, if any arise, attorney's fees, if any arise, and all other relief the court finds just and proper. Count 2. Plaintiff re-alleges paragraphs 1 through 48. Defendant City instituted Ordinance Chapter 15, Section 15-48D-E, and other practices which lead to the constitutional violations outlined in this complaint and cause plaintiff injuries, all in violation of the 1st, 4th, 8th, and 14th Amendments to the United States Constitution. The same is actionable under the 42 U.S.C. 1983. At all times relevant, and with the failures above stated, despite its notice regarding the propensity and history for defendant Delgado to engage in constitutional rights deprivations, as well as his honesty problems as seen in his report versus the police body-worn camera videos of the encounter, the city had a policy or policies related to training defendant Delgado and other officers generally, which policy was that training, in fact, was simply not required, and therefore such policies were objectively, deliberately indifferent to the likelihood that a particular constitutional violation, violently detaining and battering a citizen with zero probable cause for either, would occur. At all times relevant, the city failed to supervise and discipline Defendant Delgado by failing to supervise properly and discipline him properly so as to avoid violating the constitutional rights of citizens, even after being so warned of repeated concerns in that regard respecting Defendant Delgado by complaints, and as noticed by independent news sources videos of defendants' improper actions, which notices were wholly sufficient to put the city on notice that supervision and discipline of Defendant Delgado at least was required. At all times relevant, the city was aware or should have been aware of the need to train officers, such as Defendant Delgado, so that officers followed a policy and process of making constitutionally sound detentions of and interactions with citizens, such as plaintiff. The city lacked any policy or process to train officers or even supervisors in this regard, and the lack of such training policy, process, or program was inadequate to protect the rights of citizens by the officers who are intended to protect them. As such, the actions of the city were sufficiently deliberately indifferent to the rights of citizens that its deliberate indifference was its official policy. Had any of such proper training processes been done by the city prior to the detention of plaintiff by Defendant Delgado, the violation of plaintiff's constitutional rights would not have occurred. Even if the need to train and supervise officers generally was not so obvious as above pleaded, there was a sufficient pattern of constitutional violations by Defendant Delgado that were given a blind eye by the city, thereby placing the city on constructive notice of the need to so train and supervise Defendant Delgado specifically. Defendant Delgado violated the rights of many people before plaintiff, and he could only could accomplish that because the city never bothered to notice, care about, address, or resolve his propensity to violate the rights of citizens and to be dishonest and violent in doing so. At all times relevant, the city instituted Ordinance Chapter 15, Section 15-48(d)(c), which deliberately advocates for other than this Constitution of the United States and violates the rights of its citizens. Gain some citations. By not allowing video recording of police in public. The video recording of public servants and government officials is strictly content orientated, where the viewpoint is portrayed solely by the actions of the public servants and government officials recorded. Weather must have been rainy, I don't know. Whether they deem to portray themselves properly according to lawful constitutional activity, or whether again, sunny this time, those public servants and government officials choose to portray themselves in an unlawful, unconstitutional manner is wholly their choice, making the overbroad restrictions on video recording city police officers in public, which is imposed by the city with Ordinance Chapter 15, Section 15-48(d)(e), completely inverse to several Supreme Court rulings. Interesting. What Supreme Court rulings? Remember, he was inside a police lobby. Had the city enacted proper constitutional ordinances prior to the detention of plaintiff by Defendant Delgado, the violation of plaintiff's constitutional rights would not have been violated, and plaintiff would have no need to seek quo warranto to safeguard others. As a result, I don't know if Merv's still in here, but quo warranto, I haven't looked it up. I'm not sure what that is. So, as a result of defendant cities' improper ordinances such as citations, and the City Council having full knowledge through discussions, emails and advice from attorneys, these ordinances are unconstitutional, and enacting the ordinances regardless, and also failure to supervise and train and to properly discipline officers in the city's employ, plaintiff has suffered and continues to suffer physical injuries to plaintiff's person that are permanent and continuing in nature, permanent psychological injuries consisting of mental pain and anguish, humiliation, shame, and public ridicule. Again, you're a nonce. You deserve public ridicule. As well as suffered inconvenience, discomfort, and financial expense, all in violation of the First, Fourth, Eighth, and 14th Amendments to the United States Constitution, and same is actionable under 48(2) U.S.C. 1983. Wherefore, plaintiff demands judgment against defendant City of Punta Gorda for quo warranto, revocation of the city's charter, compensatory punitive damages in the amount of $5 million. So, if anyone said 5 million plus 5 million plus, I think it was 810 or something. So, if anyone got close to $10,810, very well done. Plus court costs, any attorney's fees, and all other reliefs the court finds just and proper. Plaintiff demands a trial by jury on all matters so triable. And there you go. Right. Now, let's see if, well, it hasn't blown it up enough for me, but apart from that, we restored this one quite well. This is the opinion and order. So, what do we reckon? He asked for $10,810. What do we reckon he got? Order and opinion. And this came in on the 21st of September, and a subscriber sent this to me. And Alex, thank you. So it's sounds very similar to a I can't think of the name, but yeah. Okay. Before the court are several motions filed by defendants Jose Delgado and City of Punta Gorda. A. Motion to dismiss and motion to strike. B. Motion to stay proceedings. Pro se plaintiff Jerry L. Hoffman Jr. has responded to all motions. For the below reasons, the court grants the motion to dismiss and motion to strike and denies as moot the motion to stay. So if you want to go now, there's the judgment. Grants the motion to dismiss and motion to strike. Let's see if it was with or without prejudice later. Background. As it must, the court treats the factual allegations in the amended complaint as true and construes them in the light most favourable to Hoffman. Citation. And it talks about the second amended complaint there. This civil rights action arises out of Hoffman's arrest in the lobby of the Punta Gorda Police Department. Hoffman considers himself a Nonce photojournalist. So on July 28, 2022, he and others went to the police department to question why no FOIA requests had been responded to and to obtain complaint forms. To capture the interaction, Hoffman used audio-video recording from the moment he walked into the building. Hoffman requested service and the officer at the public window left without returning. About 5 minutes later, 3 officers, including Delgado, approached him with recording body cameras. Another officer confirmed that Hoffman was recording and told him to step outside the public lobby because it violated a city ordinance to video record inside a city building. Hoffman refused under the name of his constitutional rights to free speech. A conflict ensued between Hoffman and Delgado. Hoffman was then arrested for assaulting a law enforcement officer, resisting arrest with violence, and trespass after warning. Hoffman now sues the city and Delgado under 42 U.S.C. 1983 for violating his First, Fourth, Eighth, and 14th Amendment rights. For their part, the city and Delgado moved to dismiss the amended complaint under Federal Rule of Civil Procedure 12b-6, and to strike the demand for punitive damages, they also moved to stay this action. Legal standard. To survive a 12b-6 motion, a plaintiff must plead enough facts to state a claim that is plausible on its face. Iqbal, there again. A claim is plausible when a plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. A plaintiff must provide more than labels and conclusions. Citation. A formulaic recitation of the elements of a cause of action will not be enough. Factual allegations must be enough to raise a right above the speculative level. When considering a motion to dismiss, courts must accept all factual allegations in the complaint as true and view them in the light most favourable to the plaintiff. Iqbal. Relevant here, pro se complaints are construed liberally and held to less stringent standards than formal pleadings that lawyers draft. Citation. But the leniency has limits. Courts neither served as de facto counsel for a pro se party, nor rewrite an otherwise deficient pleading in order to sustain an action. Citation. And that is, pro se litigants are subject to the relevant law and rules of court, including federal rules of civil procedure. Discussion. To prove a claim under Section 1983, Hoffman must 1. A violation of a constitutional right, and 2. that the alleged violation was committed by a person acting under the colour of state law. Citation. The first element is at issue. At best, the court can tell Hoffman brings these constitutional claims against the city and Delgado: free speech and retaliation under the First Amendment, false arrest and excessive force under the Fourth Amendment, due process violations under the 14th Amendment, cruel and unusual punishment under the 8th Amendment. The court will address the plausibility of each claim as alleged in turn. First Amendment. Hoffman generally argues that the prohibition on him recording in the police department is an impermissible restriction on his First Amendment rights. The prohibition comes from the city's Ordinance Chapter 15, Sections 15-48 that prohibits recording video or audio in city-owned, controlled and leased property without the consent of all people. Under the ordinance, the police department is a limited public forum. Citation. The designation means the city may regulate the time, place and manner of speech if it uses content-based regulations that are viewpoint neutral. Citation. But according to Hoffman, the ordinance is strictly content-orientated and overbroad. The court need look no further than Sheets v. City of Punta Gorda to reject Hoffman's argument. Funny that they decided to go here knowing Sheets. In Sheets, the court found the same ordinance viewpoint neutral, as it made no distinction based on any viewpoint of the individual recording, and the court held the ordinance was constitutionally permissible under the First Amendment. Although Sheets addressed restrictions with audio-video recording in public facilities like City Hall, the reasoning equally applies to recording in the police department. So Hoffman's recording in the police department was not activity protected under the First Amendment. The court thus dismisses the free speech claims. Hoffman also raises a First Amendment allegation. Hoffman also raises First Amendment retaliation claims. To state a claim for First Amendment retaliation under Section 1983, a plaintiff generally must plead that 1. The plaintiff engaged in constitutionally protected speech. 2. The defendant's retaliatory conduct adversely affected the protected speech. And 3. The Mouse, come back to me. 3. The retaliatory action caused the adverse effect on plaintiff's speech. Citation. As discussed, Hoffman's recording in the police department was not actively protected under the First Amendment. To the extent Hoffman argues that his arrest was in retaliation for exercising his First Amendment rights, the Supreme Court in Neves held the plaintiff pressing a retaliatory arrest claim must plead and prove the absence of probable cause for the arrest. Neves v. Bartlett, or as Delete Laws would say, Nivens v. Bartlett. As will be analysed in the next section, probable cause existed for Hoffman's arrest. Because Hoffman's recording in the police department was not activity protected under the First Amendment, and because probable cause existed for Hoffman's arrest, there can be no First Amendment retaliation claim. Citations. The court thus dismisses any retaliation claims. Hoffman is a nonce. Yes. If you didn't know that, Merb, Hoffman is a nonce. We found that out when he got arrested. It was a little girl. 2. Fourth Amendment. Hoffman claims that Delgado violated his Fourth Amendment rights when he confiscated Hoffman's body-worn camera without a warrant and when he battered, detained and arrested Hoffman knowingly without justification and probable cause and based upon a false and fabricated justifications on his official arrest report. And Merb, I'll send you all of these documents when I've finished. Where did I get to before I spoke to Merb? Knowingly without justification and probable cause and based upon a false and fabricated justifications on his official arrest report. Hoffman further asserts that Delgado effected an unreasonable seizure and arrest of plaintiff and used excessive force, doing same that caused plaintiff permanent personal injury, emotional suffering and other manner of damages. A person is seized under the Fourth Amendment when an officer, by means of physical force or show of authority, terminates or restrains his freedom of movement through means intentionally applied. Citation. A Fourth Amendment seizure requires an objective manifestation of an intent to restrain. Citation. Addressing first Hoffman's false arrest claims, the existence of probable cause bars a Section 1983 claim for false arrest. Citation. A law enforcement officer has probable cause to arrest a suspect when a reasonable officer could conclude that there was a substantial chance of criminal activity. Citations. In determining whether an officer had probable cause for an arrest, the court looks to the events preceding the arrest from the standpoint of an objectively reasonable police officer. Probable cause requires only a probability or substantial chance of criminal activity, not an actual showing of such activity. Take note, delete laws. And as someone says, Rogue Nation, although as long as they keep giving you the ability to fire without costing you anything, no, we don't have any amendments. The starting point here is the ordinance being constitutional, and that's a reference to Sheets. From there, Hoffman makes several key admissions. He admits that he was recording inside the police department lobby. Hoffman also says that an officer directed him outside because he was illegally recording under the ordinance. He then maintains he asked officers what would happen if he did not leave and if he would be arrested if he did not follow the officer's direction. Hoffman acknowledges that he was still recording in the lobby when he asked to speak with the police information officer and when Delgado entered the lobby. So by Hoffman's own account, he violated the ordinance and failed to comply with the officer's commands. During Delgado's attempt to arrest Hoffman, Hoffman admits saying, "Get off me, cop. You're a piece of shit. You're a piece of garbage, buddy," and admits while saying, "Get off me, man." He quickly moves his own left elbow, with left hand still holding the camera phone straight down and away from defendant Delgado, towards plaintiff, breaking the pain-compliant hold defendant Delgado had on plaintiff's person. Hoffman therefore acknowledges resisting arrest. That's why you hire an attorney to make any civil claims for you, or they're probably at for you on a why do I keep losing words? They'll act for you if there's a chance of you winning, and they'll take a percentage of the winnings. So Hoffman therefore acknowledges resisting arrest. So by Hoffman's own allegations, probable cause existed to arrest him for violating the ordinance and for resisting arrest in violation of Florida Statute 843.01, resisting an officer with violence to his or her person, and Florida Statute 843.02, resisting an officer without violence to his or her person. Hoffman's false arrest claim will therefore be dismissed. Turning to Hoffman's excessive force claim, Hoffman alleges that Delgado used excessive force when he shoved plaintiff directly into a protruding wall corner where plaintiff fell, grabbed plaintiff's left wrist and attempted to drag plaintiff towards the exit, put a pain-compliant hold on plaintiff's left bent elbow with plaintiff's video recording phone in plaintiff's left hand and pushed plaintiff towards the exit less than 2 feet away, struck plaintiff so hard the blow immediately shuts off plaintiff's recording camera phone and the damaged camera goes flying into the wall, grabbed plaintiff's left arm, again swinging plaintiff around and into a closed door and onto the floor, cruelly and unnecessarily lands on plaintiff's back with a knee strike, causing plaintiff considerable agony and bodily damage to that area, grab and twisted plaintiff's left wrist in a plain compliant hold. Sorry, I'm gonna give the defendant, Delgado, a round of applause because he did this all to a nonce. Switched knees and twisted plaintiff's left wrist viciously and unnecessarily, deliberately landing a second knee strike to the back of plaintiff's exposed neck, causing more bodily damage and severe pain. Pulled viciously and forcibly on the handcuffs straight upwards and towards plaintiff's face-down head in order to inflict more abuse and pain, very nearly separating plaintiff's shoulders out of the shoulder sockets. After his arrest, Hoffman went to hospital for scans to determine any bones broken, but no broken bones were found. The 11th Circuit says the application of de minimis force without more will not support a claim for excessive force in violation of the Fourth Amendment. Citation. After all, the right to make an arrest necessarily carries with it the right to use some degree of physical coercion or threat thereof, and the typical arrest involves some force and injury. Citation. The key inquiry, then, is whether the officer's use of force was objectively reasonable under the circumstances. Citation. The reasonableness of a particular use of force is judged from the perspective of a reasonable officer on the scene and not by the 2020 vision of hindsight. Note Chili de Castro. Hoffman went to the hospital to get checked and underwent scans to determine whether he had any broken bones. No broken bones were found. The 11th Circuit has held in similar situations that the force of which Hoffman complains was a de minimis or otherwise did not violate the Fourth Amendment. Citation. And holding that an officer grabbing the suspect and shoving him a few feet against a vehicle, pushing his knee into the suspect's back and the suspect's head against the vehicle was de minimis force. Citation. Holding that officer did not use excessive force when he grabbed plaintiff's arm, twisted it around plaintiff's back, jerking it up high to the shoulder, and then handcuffed plaintiff as plaintiff fell to his knees, screaming that the officer was hurting him. Noting that painful handcuffing without more is not excessive force in cases where the resulting injuries are minimal. Another citation. De minimis force when police slammed the suspect against the wall, kicked his legs apart, and required him to raise his arms above his head as officers carried out the arrest. So, Hoffman's Fourth Amendment excessive force claims will be dismissed. It's going well. It's going well. I don't yeah. I'm not going to try and explain things. Need to go to a lawyer to do that. 14th Amendment due process claims. Hoffman generally alleges that Delgado violated his 14th Amendment due process rights through the violation of his Fourth Amendment rights when Delgado detained and arrested Hoffman and confiscated his body-worn camera. When, as here, a plaintiff's 14th Amendment claim is brought because the alleged violation of another constitutional provision, the claim is analysed under the standard related to the constitutional provision at issue, not under the 14th Amendment. Citation. Hoffman's other constitutional claims have been analysed above. It is unclear if Hoffman makes procedural and substantive due process claims. Still, he falls far short of plausibly pleading either. As much as Hoffman brings a procedural due process claim, he must allege 1. A deprivation of a constitutional protected liberty or property interest, 2. State action, and 3. Constitutionally inadequate process. Just look at this footnote. I'll leave it up for you to read if you want to. Here, he generally claims that Delgado committed perjury in his official arrest report, but he neither offers facts on the process given to him nor allegations that any such process was constitutionally insufficient. And as much as Hoffman's due process claim is based on his challenge of the ordinance, this court already held that the ordinance is constitutionally permissible and does not deprive an individual of due process. And back to Sheets. The court thus dismisses the 14th Amendment claims. 4. 8th Amendment claims. Although Hoffman alleges that Delgado violated his right to be free from cruel and unusual punishment, the 8th Amendment applies only after a prisoner is convicted. That's probably why you should use a lawyer to file civil rights claims for you, because when you do it yourself, you make an idiot of yourself. Because Hoffman's criminal case is still pending, he is not a convicted prisoner. Without that label, Delgado cannot have violated Hoffman's 8th Amendment rights. The 8th Amendment claims will be dismissed. Municipal liability claims. Finally, Hoffman seeks to impose Section 1983 liability on the city for failing to supervise and discipline Delgado, even after being so warned of repeated complaints and concerns, as noticed by independent news sources' videos of Delgado's improper action. Respondeat superior is not a basis for the imposition of municipal liability under Section 1983. That's the word I was looking for earlier, a Manel claim. That's what that quote that Alex put up in the quote sounded like. For a municipality to face a Section 1983 liability, a plaintiff must allege facts showing 1. His constitutional rights were violated, 2. The municipality had a custom, policy or practice that constituted deliberate indifference to that constitutional right, and 3. The municipal custom, policy or practice caused the constitutional violation. Game Manel. The municipal custom, policy or practice must be the moving force behind the constitutional violation. Citation. Isolated incidents do not create a custom, policy or practice. Another citation. Although Hoffman alleges that Delgado violated the rights of many people before plaintiff, this allegation is conclusory. Hoffman also argues that the city was aware or should have been aware of the need to train officers, such as Delgado, but lacked any policy or process to train officers or even supervisors, and the lack of such training policy, process or program was inadequate to protect the rights of citizens. These allegations are also unsupported and conclusory. Unsupported conclusory allegations do not establish a custom, policy or practice sufficient to support imposing municipal liability under Manel and cases applying it. Hoffman's municipal liability claims will be dismissed. Quite like that one. Punitive damages. The city and Delgado also moved to strike Hoffman's demand for punitive damages from the city, arguing they are unavailable against government entities under either Section 1983 or Florida law. Although punitive damages may be awarded against municipal employees in their individual capacities, such damages may not be awarded against the municipalities. Citation. That is generally because municipalities are open to suit for failure to follow constitutional rights and federal law, so allowing punitive damages could create a serious risk to the financial integrity of these governmental entities. Because punitive damages are unavailable against government entities, Hoffman cannot receive punitive damages from the city. The court thus strikes Hoffman's demand for punitive damages. 7. Qualified immunity. Delgado also moves for qualified immunity. Qualified immunity is a defence that shields officials from civil liability so long as their conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. And citations. Plaintiff has not stated a constitutional claim for which relief can be granted. Because there are no underlying constitutional violations, the court need not explore qualified immunity. Motion to stay. The city and Delgado also moved to stay this case because of Hoffman's pending criminal charges and their intersection with his malicious prosecution claim here. But Hoffman concedes the dismissal of his malicious prosecution claim. Because of his concession, There is no need to stay this case because of the criminal charges. The court thus denies as moot the motion to stay. Accordingly, it is now ordered: 1. The motion to dismiss and motion to strike is granted. The amended complaint is dismissed with prejudice. Interesting, in this case, they've actually stated with prejudice. In the case recently, who just got dismissed? It was Delete Laws, wasn't it, in Ohio? They put in a footnote that the motion, the dismissal was with prejudice, and that should be taken as read for that type of dismissal. 2. The motion to stay proceedings, or in the alternative, motion to abstain and dismiss without prejudice with incorporated memorandum of law, is denied as moot. And that is it. So, sorry about that. It's a very long live stream, for which I do apologise. My voice is going to go, so I don't know if I'm... let me just have a look at the comments that I can see if there's anything that I should have seen and brought up. I don't know what the argument between Rogue Nation and Desert Sentinel is. Rogue Nation, I mean, when are you going to get one that survives? There haven't been many big claims. The successful claims that I can pull off the top of my head are, I believe, Chi-Town Sue has won some, Pink Camera Magic, I think. Fast, First Amendment Strike Team. He won one in Colorado. You've obviously got the Leon Valley people who won. Theirs was probably the biggest claim that I'm aware of from a so-called First Amendment auditor. Thank you, Alpha66. I do appreciate that. Hopefully you found that interesting. I've listed the videos in the description to this video of my previous videos about this event. Yes, he is a nonce. He deserved everything he got, and he's not getting any money from a cop or Punta Gorda. It's interesting it happened in Punta Gorda. Interesting it happened in Florida. Rogue, interesting for you. When are you going to have a successful one? And when are the state going to get fed up with you filing frivolous claims?